hear you. All present have been due to the Honorable Justice of the Appeals Court, now sitting in Washington, the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, everybody. Welcome to the sitting of the Appeals Court in the Armstrong courtroom on March 18th, 2025. This is our second argument of the day. Our first argument, we had to do it on Zoom because it involved a self-represented inmate. So it was, and so I apologize for not being here, but here we are on the record. Your panel for today is I'm Justice Greg Massing. To my right is Justice Eric Nyman. To my left is Justice Chauncey Wood. The rules are pretty simple, 15 minutes per side, no rebuttal. We have read your briefs, and so you can jump right into the argument. We're familiar with the case. As I said, you have 15 minutes, and you feel free to use all the time, but also there's no penalty for finishing early. And with that, I'll call the second case for today. And I'm sorry, and I want to welcome the faculty and students from the University of Massachusetts Law School. Is that right? Mass School of Law in Andover. Sorry about that thing. Welcome, everybody. So the second case is 24P483, Tresh versus Hansen.
Good morning, Your Honors, and may it please the Court. My name is Jessica Savino, and I represent the defendant appellant June Hansen. Your Honors, before I begin, may I please reserve 2 minutes for rebuttal?
No, we don't have rebuttal in the appeals court. Try and anticipate what he's going to say.
Thank you, Your Honor. Your Honors, a decision to grant a new trial should be reversed if it is based on a significant error of law or an abuse of discretion. And here there was both. First and most egregiously, the judge impermissibly shifted the burden of proof onto the defendant. It is a fundamental principle of law that in a civil negligence case, the plaintiffs have the burden of proving each element of their case by preponderance of the evidence. This is not a burden-shifting framework, and the defendant does not need to disprove anything. While the defendant here stipulated to two of the elements of negligence, duty and breach, this did not excuse the plaintiffs from needing to prove the remaining two elements, namely that there was an injury and that the injury was actually caused by the defendant's negligence. For this burden of proof to mean anything, a jury must start from the position that the plaintiffs have not proven anything, that there is no injury and that there's no causation. The jury can then look at all the evidence presented in the context of the entire case and determine whether the plaintiffs have actually met that burden of proving that there was injury and that it was related.
I was under the impression that the judge, rather than shifting the burden, made a determination that no reasonable juror could have found that the defendant's conduct did not cause the injury. And in his words, the judge said, look, even your expert acknowledged that there was whiplash, that they were taken away, I think, on gurneys or what have you, and by EMTs and taken away from the scene, and that even if the injury was arguably even de minimis, even your expert acknowledged there was some injury. What do you say to that?
Certainly, Your Honor. I'll skip right to that part. For the soft tissue injury, the court did point to testimony by Dr. Saras saying that if there was injury, then it was a soft tissue injury. However, Dr. Saras also testified that there was no objective evidence that the plaintiffs were injured at all. And he explained that any evidence of soft tissue injury, including his own opinion,
Was subjective.
was based entirely on the plaintiff's subjective complaints. And he took those complaints at face value. But a jury did not have to do that. If a jury found the plaintiffs not to be credible, then Dr. Saras' opinion that there was, in fact, soft tissue injury would be based on nothing at all. And an expert opinion, even if they're an expert, if their opinion is based on nothing or no credible evidence, then that opinion doesn't mean anything.
What about the whiplash?
So whiplash, Your Honor, is part of the soft tissue injury that's been claimed. And Dr. Saras did testify that any other sort of neck symptoms, including the degenerative spinal condition that was seen on imaging, is something that can't be caused in just an accident. It takes years to develop and is not, and he was quite firm on that specific injury not being related. The only injury that he was saying he was assuming was related based on what they were saying was soft tissue, whiplash being a soft tissue injury. But again, if those if their complaints were not credible, as there were plenty of evidence introduced suggesting that they were not, then his opinion would be based on no evidence at all, making it not actually an opinion that could be considered evidence of injury.
So you're right. The jury is free to make credibility determinations, but in a motion for a new trial on the ground that the verdict is against the weight of the evidence, isn't the judge permitted to make credibility determinations? I mean, it's not like a motion for a directed verdict where you have to give everything in the most light, most favorable.
Certainly, Your Honor. And if it were a matter of the judge testifying as to what the evidence, or not testifying, but looking at what the evidence actually was and saying this evidence and do they balance, but he did not consider the fact that the jury could have found that there is no evidence. And again, because
the jury could have found that, but the judge, I think the judge's determination was, but that would be against the weight of the evidence that he saw.
And I believe in that case, Your Honor, that the judge is substituting his own opinion for that of the jury. The judge,
that's my point. Isn't he allowed to, in a motion for when a new trial based on it's against the weight of the evidence?
Simply granting a motion for a new trial because he disagrees with how the jury interpreted that evidence and the weight that they gave to it is not permissible. The jury is entitled to weigh the evidence, and the judge can look at that evidence that they've weighed, but he can't just disagree. And this judge particularly made it clear before there was any evidence presented at all that he'd already made up his mind.
Let me ask you a different question. This is the appeal after the second trial, correct?
Correct, Your Honor.
And you're raising no issues involving the second trial?
Correct. This appeal is based entirely on the grant of a new trial.
I mean, at the second trial, one of the things that Judge Wilkins seemed to chastise himself for was actually giving an instruction on causation. In the second trial, was there an instruction on causation?
Your Honor, I was not trial counsel. I don't actually have the transcript from that trial.
Can I ask a slight variation on? It seemed to me that Judge Wilkins was taking a couple facts, the photographs of the crash and the amount of damage to the rear end and the undisputed recognition that this was caused by the negligence of the defendant, and making the narrow point that at the very least it's reasonable medical care for the paramedics in this context to put these people in an ambulance and take them to the hospital to ensure that they're okay. And at the very least, he seemed to be saying everybody has to agree that in this context, that's the reasonable thing to do. And even if, as a result, there are no injuries detected that will at least warrant medical attention, that's a medical expense caused by the defendant's negligence. What do you say to that?
I think that's an example of the court looking at exhibits that were going to be introduced ahead of time before any evidence had been presented to a jury and making that determination on his own. The fact that the plaintiffs decided to go to the hospital is not a foregone conclusion. People react to injuries or the potential for injuries in all sorts of ways. Some people might be in the exact same accident as was here and could be paralyzed for life. And some people might walk away without a scratch. And the decision to go to whether to seek medical attention or not is going to be a very individual one based on whether there was actually injury. And people present for medical treatment or evaluation in the context of car accidents all the time for a variety of reasons, including the desire to create what may be a baseless personal injury claim. And so the fact that they went to the hospital and presented does not mean that they were justified in doing that. They may have known right at the scene that they were completely fine and were not going to present to the emergency room with any injury. As was the case, they were documented to have no injury. And so the fact that they took that ride does not in itself mean that it was caused by the accident and necessary. The plaintiffs chose to seek that treatment, again, with there being no objective evidence of injury. And so the fact that they presented in and of itself does not necessarily mean there must be a finding of causation. And that essentially is what the trial court is saying here, that whenever anyone is in an accident and they've stipulated to the liability side of things, if they sought medical treatment, then there must be causation. And that's just not the law in this Commonwealth. The element of causation is the quintessential question of fact for a jury to decide. And this court has wisely said in the past that when a party has the burden of proof, it can very rarely be ruled as a matter of law that that burden has been sustained.
What's your very best case for the proposition that the judge abused his discretion here?
So his abuse of discretion was threefold.
No, your very best authority, legal case. What is your best? I understand the principles, I understand the standard of review. But do we have a case that's like this, where the judge actually stated the correct standard? He said that it was not reasonable for the jury to make this determination. It was against the weight of the evidence, and it resulted in a miscarriage of justice. So that's your challenge to overcome. What is the best case you have that we should be taking a long look at?
Your Honor, I would point to, for the fact that because a jury could have found for the plaintiffs in the first trial does not mean that their verdict is against the weight of evidence or inconsistent with substantial justice. I would point to Joken versus Durker, 425 Mass 565.
And I know you said you weren't counsel on the second trial, but I'm curious, in view of the verdict and the damages amount in that case, was there a 59A motion to alter or amend the verdict filed, or a motion for a remitter or anything like that in the second trial?
I don't believe there was a motion for remitter, Your Honor.
And no motion to alter or amend the judgment? No 59A motion?
Your Honor, the trial counsel for the second counsel actually left very shortly after that trial completed, and so we went right into the appeal process.
Okay, thank you.
Going back to the issue of burden of proof, the judge here, and the reason that we're arguing that he applied the wrong burden of proof, is he made it very explicitly clear that he was looking for the defendant to introduce, quote, evidence from which a reasonable jury could find there was no injury at all. The defendant did not have to introduce evidence of this fact. If the correct standard is applied, then there being no injury would be the jury's starting point, their baseline, from which they then had to look at the plaintiff's evidence to determine if they had met the burden of proof. And in looking at that evidence, they would also account for whether the plaintiff was credible, given that their claims relied entirely on their subjective complaints.
Could you give me a page reference for where the judge says that?
Where the judge says,
Where the statement where you say he changed the burden of proof?
yes.
I have your brief out and the...
Oh, here it is. On 396 in Volume 1.
396. And that's in the argument on the motion.
I'm sorry, Your Honor?
You're citing a transcript page there.
Yes, at line 8 to 10.
Is that in the written decision as well?
The written decision has slightly different wording and the same general concept. He wrote in the decision on, let's see. That's not the right page.
How is that burden shifting? I know you're looking for in the motion for new trial, but so lines 8 to 10 at Record Appendix, Volume 1, page 396, the judge says, the question is whether there's any evidence from which a reasonable jury could find there was no injury at all. Why is that burden shifting?
Because he's asking for evidence of no injury. He's asking for proof of the negative. The burden is not on the defendants to prove the negative. The burden is on the plaintiff to prove the positive. And if the jury does not believe the plaintiff's evidence, then they should still be at the no injury that they started with. They should be starting from a point of no injury, no causation, and going from there if they believe the plaintiff's evidence. If they don't believe the plaintiff's evidence, then they should not be moving on from no injury.
I have a, sorry, go ahead.
Just my follow-up. Mr. Price, was he attorney for your client?
He was, yes. He's the one who left right after.
Right, so the judge says, but the question is whether there's any evidence from which a reasonable jury could find there was no injury at all. Counsel for your client says, right.
In reviewing that entire interaction, I believe his phrase there was more in the allowing the judge to say what he was saying before continuing with his argument, because he does continue an argument after that.
Okay.
You're almost up, but if the chief of the panel will allow me to ask this question. I think I'm looking at page 4 of the judge's decision, down at the bottom, quoting the judge. No reasonable person could believe that the plaintiffs suffered no medical expense caused by the accident. Double negative confuses me, but in any event, I think I understand what he's saying. Let's say I disagree with him. My reading of the transcript, let's say, is I think it's possible that a jury reasonably could say they're lying liars and they shouldn't have even needed to go to the hospital. What's the level of deference I'm supposed to give to the trial judge because he was there, I wasn't there?
So the level of deference is that it has to be reasonable. It's a reasonable discretion. It's not just any discretion, any decision that he wants to make. And so the discretion is not being exercised reasonably when it's relying on the wrong standard of proof, when it's removing an element from the jury, and when the facts pointed to by the trial judge are not saying what he wants them to say. The evidence is not that there was certainly soft tissue injury. The evidence is that everyone relied on their the subjective complaints, and if those were not correct, then there's no evidence at all.
So you're saying it's a reasonableness standard, so you would agree that the LL versus Commonwealth standard on abuse of discretion applies, whether or not it's outside the range of reasonable alternatives?
I agree as to the abuse of discretion part that, yes, it's reasonableness.
So answer my question. Are you agreeing that LL versus Commonwealth, which is sort of our modern standard for abuse of discretion, is what applies to this case?
Yes, Your Honor.
Okay, thank you.
I see my red light is on. Does Your Honors have any other questions?
I think we're good. Thank you.
Your Honor.
Thank you.
We'll hear from
Attorney
Attorney Conley.
Good morning, members of the panel. May it please the court. My name is Gregory Conley, and I represent the appellees in this proceeding. Having listened to my sister and understanding my time allotment, I would like to focus a little bit on this argument of a shifting of burden, if you will. I think it's a clear picture that Judge Wilkins paints at the conclusion of the evidence, when he comments on the fact that Dr. Saris, for instance, does not explain to the jury why soft tissue injuries such as whiplash, which Dr. Saris said are very common in these kinds of accidents, are very painful for periods of time but resolve on their own, represented some kind of burden shifting. Judge Wilkins was simply commenting on the state of the evidence and whether or not it was reasonable for this jury to come to the conclusion that it did.
Yeah, but can I interject there? I understand that that's what Judge Wilkins said. I understood Dr. Saris to be saying, look, I wasn't there. I can't tell you whether they suffered whiplash. I'm going to take their claims at face value. All I can tell you, and his report on this is very clear, there's no concrete, objective, imaging, radiological evidence of this injury. Did they have an injury? I don't know, because it's entirely subjective. And the point I think that your opponent is making is that's not evidence, that he's not conceding, as Judge Wilkins claimed, he's not conceding that they had injury. He's saying there's no evidence of the injury beyond their subjective report of this, and the jury is free to reject that. So it seems to me, my reading is that Judge Wilkins got that wrong. So if you could address that.
Well, Your Honor, I would disagree with my sister's characterization of taking their concerns at face value, because Dr. Saris reviewed the EMT trip ticket, which clearly showed that Mr. Koska had an abrasion to his forehead after he complained to the EMTs that he struck his head on the roof of the vehicle. He had an abrasion to his left knee that the EMT documented. These were also documented at Berkshire Medical Center. So how Dr. Saris could later opine that they sustained no injuries because there was no objective signs of them is beyond me. It seems like it's ignoring.
On that point, I dug into that. So if you go and look at the, I don't mean to make light of this, but if you go to the ER record, first of all, it says head trauma, none visible. So that's interesting to me. And then abrasion, I believe you characterize, I don't know if it's you, your brief characterizes it as fresh. It's actually not, that's a word that was not used in the medical records. So what we have is an abrasion on the knee. And so that led me to the question of de minimis, a concept of de minimis. So there's contradictory evidence on whether the guy has a contusion. It's not an abrasion, a contusion on his forehead. He tells the EMT, or the EMT notes a contusion. The ER notices no visible head trauma, which I would think would be the contusion. So that's just contradictory. But focusing on the abrasion, if it's not fresh, it's just an abrasion on his knee, is that a basis to send him to the ER?
Well, he was complaining of neck pain as well, Your Honor, which is, I think, why they decided to transport him. They put him in a collar. He was complaining of being claustrophobic, but when the EMTs were explaining to him the fact that he was complaining of neck pain, that this was the appropriate protocol to make sure that they could get him to the medical center safely. Dr. Saris, though, also ignores, Your Honor, the fact that the day of the accident, Ms. Tresh has a cervical MRI, a lumbar MRI, which shows a herniation at L4-5 corresponding with her complaints of numbness and lack of sensation in her lower extremity.
Could you give me the record citation on that?
I'm sorry?
The record citation, RA site for that specific MRI result?
I can, Your Honor.
You can do it in a post-argument letter if you want. I don't mean to derail you. And I can find
Your Honor, I'm sorry. It's Record Appendix Volume 2, 0557, demonstrated MRI of Tresh cervical spine degenerative changes at C5-6.
Right, I saw that. That's degenerative. That is, I understand it, is not something that occurred that day. That's from arthritis, as I understand it. But what you just said is different and much more interesting to me.
It is, Your Honor, and I apologize for not being able to find the site.
Again, I don't mean to, I don't want to be unfair to
Yeah,
you.
let's move on right now. I don't want to
Apologies.
take your time with this, but
Right.
let me tell you, well, let me start by saying what bothers me is certainly not a legal standard. Perhaps it should be, but it's not. But here's what bothers me. You have a case where Judge Wilkins essentially said, look, at a minimum, there was some injury here. There was some causation of some injury, perhaps de minimis, but you've got something, whether abrasions, whiplash, etc. So then on retrial, the jury comes back with a very significant verdict that seems entirely inconsistent with what Judge Wilkins had in mind. What do you say about that? That does not sound to me like the result that was
Well, Your Honor,
Received
I was...
and foreseen.
I'm sorry for interrupting. I was trial counsel for both cases. It was a different judge, as you may know. I did ask that an instruction on causation not be given based on the state of the evidence, and the trial judge elected to give that. But Ms. Tresh had a very serious and complicated medical history following that accident. She had fusion in her cervical spine, which was deemed to have been a failure. She had ongoing lumbar problems, where surgery was recommended, but because she had had a bad experience with the cervical fusion, she elected not to get the lumbar surgery. And Dr. Goldman gave her a fairly significant impairment rating. And I think those points I tried to drive home in both trials, but I was more successful, obviously, in the second trial of persuading a jury that her injuries in particular were quite significant.
And when that second jury came back, you could confirm there was no 59A motion, no motion,
There was not, Your Honor.
no motion to alter or amend the verdict, no motion for remitted of any kind?
There was not, Your Honor.
Okay.
I think the key to the trial, Your Honors,
Seems like it might have been a great case for one, but that's not what we're dealing with in this record, so.
No, Your Honor. I do think that the key to the case is this concept of reasonableness. And was it reasonable? Because Judge Wilkins has a duty to determine whether or not the jury carefully and thoughtfully considered the evidence that was introduced at trial. And there was no evidence that they weren't injured. No one testified that, oh, you know, Tammy's my friend, and she told me in a bar 3 weeks later that she wasn't really hurt, but she was making it up for a personal injury claim.
Sorry, you just said there was no injury that they weren't, there was no evidence that they weren't injured. This is, again, to me, this is making your opponent's point. This is the double negative. That is burden shifting. There's no evidence that they weren't injured. What I want to know is it reasonable for a jury to find that they weren't injured? Or in other words, that you failed to prove by preponderance of the evidence that they weren't injured. For example, Mr. Koska might have been a drug seeker because he had just filled a prescription 48 hours earlier for 120 Vicodin. Like, that's a simple jury question. He's a liar. And what I'm troubled by is this notion that Judge Wilkins is actually acting as a 13th juror. I believed your clients. I didn't believe, I believed your clients, period. They weren't lying. There's no evidence that they weren't injured. That to me doesn't make any sense.
Well, Your Honor, on pages 18 through 25 of my brief, I try to recount the objective signs of injury that were documented by a total of like 18 medical professionals who were involved in their care, including her neurosurgeon, as well as the orthopedic surgeon, Dr. Goldman, who offered an opinion as to her permanent impairment. So the jury apparently discounted all of those I'm sorry.
So I don't mean to be excessively argumentative, but I went through that list, your list. I was focused on that, the objective evidence of injury. And as a non-doctor, I compared that to what Dr. Saris says in his report and in his testimony. And what I take from this, and please correct me, is these are all historical injuries. The imaging reveals to us that she has either prior injuries or arthritis, but that none of this imaging, to which you characterize as the objective evidence of injury, is caused by this accident. Is Dr. Saris objectively wrong about that?
I believe he is, Your Honor. I believe that the neurosurgeon who reviewed the cervical MRI, as well as the lumbar MRI, Dr. Fraser, and came to the conclusion that herniation was related to that accident and performed surgery on this woman 6 months later. I think Dr. Saris is dismissive of that because he was a defense expert. That was not going to be helpful to him to say
Why isn't that a jury question?
Well,
It strikes me as a classic jury question, and that's the problem with this case.
It is a jury question, Your Honor. But again, I think Judge Wilkins was focusing on the weight of the evidence that was presented at trial. And Dr. Saris does state, when asked directly, do you have an opinion as to whether or not Ms. Tresh was injured as a result of the accident? He says yes. Attorney Price says, what is that opinion? My opinion is that she sustained a soft tissue injury that resolved 11 months later. And I know there's a lot of discussion, well, but if the plaintiffs were lying to him, then his opinion would be unfounded. His testimony is based on reviewing, according to him, thousands of pages of medical records, the operative notes, the examination of Ms. Tresh, the deposition testimony that was offered by both of them. It is not simply what she may have told him in what she characterized as a 10-minute examination, independent medical examination, in an office in Worcester, in a law office in Worcester. It was hours and hours and hours and $37,000 worth of work where he came to the very specific conclusion when asked directly by his counsel, my opinion is that she sustained soft tissue injuries that were very painful but were resolved by July of 2015. And he says the same thing about Mr. Koska, that those injuries would have resolved in January of 2015. He does not qualify those opinions to say, if they're lying to me, I don't have that opinion. That's not what he said. And I think it was unreasonable for the jury to simply dismiss that opinion when it was also buttressed by treating neurosurgeons, treating orthopedic surgeons, again, 18 other professionals that were involved in their care that all came to the same conclusion that these people were not lying to me, and this, our opinion is we're treating them for these injuries, as well as the testimony, obviously, of the plaintiffs. And the jury is free to disbelieve everyone, I guess, but as Judge Wilkins said, is that reasonable? That this jury can simply disregard what everybody said and come to the conclusion that there was no causation?
Is it, there's the August 2013 accident, right? So putting aside Mr. Koska, I think the much stronger argument, the client with the much stronger argument is Ms. Tresh. She had an accident in 2013, the exact same kind of accident, right? Rear-ended, right?
That's correct, Your Honor.
And she suffered some pain. She said, she's very clear that the pain she suffered there was back injury, not neck injury. But am I right, and this is a bit ambiguous, she didn't tell her treating physicians about that accident. And she, specifically, I could find the transcript site, but after cross-examination, which Judge Wilkins didn't like for some reason, she says, I guess not. I guess I didn't tell them about that. That's a big problem if the jury's job is credibility, because it's not, to me, that suddenly transforms this from, she's not lying, but rather she does have pain, it's from something else, and here's a chance, the jury might think, to get the operation that she needs without having to pay for it.
Your Honor, I'm very familiar with that testimony. I believe what she said at trial was she injured her low back and that she had a shot, I believe, of Toradol, one shot at an urgent care facility, and then her pain resolved. Her operation was her cervical, not her lumbar. She did not complain of neck pain following that rear-end accident, and she was at a stop, I believe, when she was struck, a low-impact accident. But you're right, I do not believe she reported that low back pain from a year earlier, either to Dr. Strobel, her primary, or perhaps even some of the follow-on doctors who were more concerned about her neck.
Right, and so, I know your time is up, but if I could, just casting that to, throwing that problem to the jury, then is it, Judge Wilkins, is he overstepping to say that the jury, faced with this conundrum, was unreasonable to find that you had failed to meet your burden?
Your Honor, again, I believe that Judge Wilkins, based on his evaluation and examination of the weight of the evidence, could have reasonably concluded that this jury was not misled by Ms. Tresh, who reported low back pain, not neck pain, a year earlier, and that the substantial evidence that was introduced made it unreasonable for the jury to conclude that she sustained no injuries as a result of this relatively significant rear-end accident.
Thank you.
Thank you, Your Honors.
Thank you both. Case is submitted. Very interesting case, well argued, and gives something to think about.
Thank you.
All right, the next case that we'll be hearing is BC Construction Company versus Johnson Roberts Associates, 24P627.
Good morning. May it please the court. Kevin Polanski on behalf of the appellant, BC Construction. The lower court, excuse me, a little under the weather. The lower court committed a reversible error by awarding summary judgment to the defendant, Johnson Roberts Associates, JRA, on the 2 counts that were filed against them for intentional interference with advantageous relations and defamation. Specifically, the court overlooked 2 things in finding for count 1. The court did not weigh the evidence in the light most favorable to the appellant, or the plaintiff in that case, the non-moving party, but instead overlooked serious material facts that should have been looked at favorably. First and foremost, this was a relationship that began in 2013. My client was a public general contractor on a public construction project in the city of Everett. The architect for that project was JRA, Johnson & Roberts. That project was completed in 2013-2014. 3 years later, unsolicited, they provided a comment. The Massachusetts Commission of Libraries was looking for the LEED certification for that project. And unsolicited, in response, when they asked for an update, they said, I don't know if you've heard, but this was one of the worst projects that we've ever had. It wasn't like any other. If I could have, I would have disqualified them on that project. That was their language. 3 years.
Is that an honest opinion?
Is it an honest opinion?
Yeah.
I think, well, it can be taken as a fact.
Sorry, it can be taken as a fact. I agree with you, it can be taken as a fact. Is it an honest opinion?
Is it an honest opinion? I am not sure.
Right, and if it is an honest opinion, isn't that protected?
Well, no. If it's an opinion, certainly it can be protected. But if it can be construed in 2 different ways, the ambiguity goes to a jury. So, if it's their honest opinion, sure. But what it goes to show that opinion isn't the issue. That shows the ill will. If that's what they believed, it shows that this was their pretense when they looked at the 2019 review. That's how they thought.
Well, but is it a pretense, or is it? I mean, they're, as the architect advising on the procurement, they're supposed to bring things to the attention of the, of the town, right? I mean, isn't the very bad the experience they had, isn't that totally relevant to what they're supposed to, what their role as architect is?
Well, it can be. Certainly if the reviews are part of the submission from BC Construction, right? So when they submit their DCAM submission, they provide references, projects that are within a certain period of time. Now, this is a 6 years old project, which doesn't show up on their DCAM review. So their personal reference or failings may not be applicable. In fact, when they looked at or they sent an email to the IG asking for advice on this, whether they can disqualify.
The AG.
No, this was the Inspector General.
I'm sorry, I didn't see that. I thought it was the Attorney General.
Oh, it was the AG. I'm sorry. Yes.
Okay.
I'm sorry. They asked for advice on that, and they said, if it's based on your own personal reviews, you've got to look beyond that. You've got to go and look to see whether there are other references. You can't
do your own diligence.
That's exactly right. But here there was...
And there was testimony, I believe, from... now I can't remember his name, but it's in the record appendix. There was testimony that they did do their own diligence, and it pretty much confirmed. In fact, this is the deposition. I'm at record appendix, volume 1, page 193. This is the deposition of Ellis. I'm going to mispronounce this. Neophotistos. And it says. And then it says here that part of the AG's guidance is that the town should do its own reference checking of your client, BC Construction. Do you remember if the town did do its own reference check of BC? Answer, yes, we did. What did that entail? That pretty much confirmed what Johnson Roberts had said.
And so I asked at that deposition, were you involved in those communications? And he says, I made 2 calls. And what did they say? I don't recall. He doesn't actually recall what was said in those communications when checking those references. I mean, it does go to sort of the improper and ill will when, you know, we know that there's an animus. We know from the testimony of Colleen Mejia, who was the city solicitor for the city of Everett, and they say, this project was not amicable. The parties were not amicable. 3 years later, they make the statement that this was one of the worst, although they testified in their deposition that, you know, their work was average. They weren't really, they tried to downplay the issues with, between the parties. But the communications, even to the IG, where they say they want to reject them based on their own personal, you know, their own personal interactions is evidence of an ill will.
So you've said ill will 3 times, and I focused on ill will because it's problematic to me. I went to the case law, and I see where you got it. But in Cutting Edge, I think Justice Englander does a good job articulating the precise language is improper means or motive or means. Yep. And you distinguish motive from means and say, so this is means, not motives. But the point Justice Englander is driving home is ill will can be, well, he doesn't focus on ill will. He focuses on improper. It has to be deceitful. It has to be lying. So you've got honest opinion over here, as I understand Justice Englander's teaching, and deceitfulness. In other words, I really thought he was a bad contractor, public municipality who's using taxpayer monies. We want your honest opinion. Or I'm lying because I don't like him personally, so I'm going to try and undermine his business. What evidence do you, first of all, do I have that right? So it's got to be deceitful ill will, right?
Sure, there has to be some dishonesty, yes.
Right. And what's the evidence that it was deceitful? That it wasn't just we don't like him because we didn't like working with him?
There's a lot of evidence. First of all, with respect to the city, the town of Norfolk, there was evidence that the owners provided that BC Construction was excellent. There was an article that was referenced in the emails that they found when they were reviewing the Cambridge project that says there's an article where the city's actually suing the architect. The architect that said, I would never work with them again. And they also sent a letter in saying, these issues stem from the architect. That evidence never showed the light of day when they submitted those Drake responses. They didn't provide that evidence to the board and said, hey, by the way, the town of Norfolk disputes everything the architect is saying, and by the way, they're suing them.
The AG gave an opinion to one of the towns saying, if you've got 1 bad review and 100 good reviews, you can rely on the bad review to pass over this person. So why doesn't that principle govern here?
That doesn't find its way in any documents. That's a reference that JRA makes to town of Drake. When you look at the email from the AG's office, that reference is not in there.
Sorry, I think I understand what you're saying. I just want to make sure I'm understanding it. That you're disputing that the AG actually said that.
Correct.
Okay, and okay, fine. Are you disputing that principle, though? In other words, if there in fact is 1 bad review and 100 good reviews, that the city has to choose your client if they're the lowest cost provider?
Am I disputing that fact? I'm not sure that I am disputing that fact. It's not a statement that we've looked into.
But sorry, I don't mean to confuse this and go down a rabbit hole. But Norfolk said good things about him. Okay, my point is, so what if you can point to places in the record where other municipalities liked your client, that there are lots of folks out there who like your client. That's fine, but is JRA doing something wrong if they say, we worked with him, we didn't like him? And Drake goes out and finds other people who said, yeah, we worked with him and we didn't like him. Why is that eliminated by the fact that Norfolk did like him?
It's supposed to be a fair process. And providing fair information to the owners to say, hey, by the way, you have the architect, which generally are at odds with contractors. They have to review their invoices. They have to, if there's a change order, it can be related to a design. And so there's at odds where the architect, in fact, you saw the email in 2016, and I'm going to address your question, but the email in 2016 where they say architects can't even fill out the DCAM scores report. The law was changed. It's the owners now, because they're generally at odds. And so if you don't provide all the information and say, hey, by the way, this architect would never work with them again, but the town had no issue with them, and the town actually says the architect lacks the credibility. That's something the town should know. What's interesting here is that when JRA wasn't the architect for the Drake in Cambridge, those municipalities awarded projects the following years on different projects to BC Construction on the same reviews, on the same references. So, I mean, that is a fact that should have been weighed in our client's favor when reviewing this. Like, that's an issue that goes to the jury. More importantly, on the December 2019 recommendation from JRA to Drake, a non-signatory to that letter was the OPM, the owner's project manager. Why? Because they had just recommended them to be the lowest responsible in a project in Newbury the month before, and so they said we wouldn't sign on to it. But yet they incorporated their prior letter that the OPM did sign on to in their December 2019, but they don't mention the fact that our OPM on this project, by the way, recommended them as being responsible in Newbury. That is something the town should have been aware of. Then you get into the Cambridge project the year after. In Cambridge, I find this remarkable. Jeff Davis says, he testified, I wasn't involved in the City of Everett project. I don't know how they were. But yet in his first email, after the lowest bidder comes back, he says to the City of Cambridge, if they weren't one of the two contractors that excuse my French, sucked, I don't know who was. He wasn't even involved. So how is it that he can make that reference when he wasn't even involved in that work? Because the inference is they're talking about BC. They're saying BC is awful. You can't use them. So he set out to provide a recommendation, and he says in that email, this might take a while. I've got to really vet them. 6 days later, they make their recommendation, and what do? They reject them. Now, except this time around, they incorporate the Drake letters. They incorporate the Drake reference reviews, but they add a very important statement. They say that many, now if you look at the number of projects, there's 10, right? And so again, you're looking at a small period of time when they're doing their DCAM reviews, when you submit that bid, there's 10. And they said many of these projects require litigation to complete the project. That statement is materially false.
Yeah, I wanted to ask you about that because, correct me if I'm wrong, you dive into the difference, you focus on completing the project. I want to make sure I understand what actually happened. 4 different times, your client completed the construction phase of the project and then said, there's upcharges, and goes to the city, the taxpayer, and says, you need to pay us more money than the contract. And the city says, I don't know what the city says, but they engage in either mediation or litigation, I think actually litigation, 4 different times to get the payment for the upcharges. And you're saying, yeah. So we finished the project first and then had to sue them to get paid. That's not completing the project. We completed the project. And the JRA is saying, well, our view of completing the project is once the city is free and clear of the contractor. That's where you guys disagree, right?
Yes, Your Honor.
Okay, so you did, not you, sorry. Your client did engage in litigation to get paid for upcharges with 4 different municipalities prior to this point.
I don't know if the number was 4. I think they did say litigation and mediation as a group number.
Okay.
I do take a little bit of umbrage as upcharges. They're changes, and usually they're design changes where they are disputing with the architect. But yes, the answer to your question is yes.
And you're saying that claim was defamation?
Absolutely. Because if you see in the...
But only the portion of the claim, only the portion of the statement that says in order to complete the project, correct?
Exactly. Because that is such a false statement. It's important. Because if you saw in Phil O'Brien's testimony, he says, I've never seen a project, where litigation was required to complete the project. In fact, he goes on to say, I don't even know what that statement is based upon. So when you look at a reckless disregard, those statements were nowhere in the 2 Drake letters. They're found in the Cambridge letter that relies on the Drake letters and is added. Then when we asked Phil O'Brien in his deposition, well, can you explain what he meant there? He said, I don't know. Well, are you aware of any projects that required litigation to complete? I'm not. I don't even know what he means by that statement. It wasn't until this litigation that they brought an expert that says, well, the complete construction means, all the payment change orders. But to the testimony of the architect that works at J. Ray, he doesn't know what that statement is, because that was his testimony at his deposition. I don't know what he meant by that. It's only later that they get an expert and say, well, completed project means any payment disputes, any payment liens. But that's such an offensive statement because the first bullet point in the city of Cambridge's response to reject them just days later is litigation or mediation. If you don't have that statement in there, 2, 3 of the 5 bullet points go away. And so that is a reasonable inference that statement caused them to reject the project. And it has to be viewed in the light most favorable. The jury may reject our inferences and evidence, but it goes to a jury. That's an issue, a disputed issue of fact that the lower court didn't view in the light most favorable. If the justices have no further questions, I rest my papers. Thank you very much for your time.
Thank you. We'll hear from Attorney Orlando.
Thank you, Your Honor. Stephen Orlando for Johnson Roberts. Before I begin, I think it's important to address a factual error that counsel just raised. Mr. O'Brien did not know about the Cambridge review because he testified he wasn't involved in it. Jeffrey Davis and Michael Bellafuel from Johnson & Roberts were the ones who conducted that review. And in fact, what you'll see in the record is that Michael Bellafuel is the one who conducted the reviews of the recently completed projects and summarized that conclusion that to complete projects, there had been litigation or mediation. And Jeffrey Davis testified, well, I relied on my colleague's review. I included that in the summary. So the fact that Mr. O'Brien doesn't know about the content of that Cambridge review actually makes a lot of sense because Johnson Roberts isn't just conspiring to get BC. Phil O'Brien did the Dracut review, not the Cambridge review. So he's not really that involved in the Cambridge review. The issue in this case is whether Johnson Roberts was entitled to fulfill its contractual duties to its clients, Dracut and Cambridge. Chapter 149, Section 44A required Dracut and Cambridge to select responsible bidders for their public projects. And although I agree the process should be fair, I wouldn't say the purpose of that is fairness. The purpose is to find a responsible bidder, to make sure that taxpayer dollars are being spent wisely. And therefore, it's relevant for a town to know, does a contractor engage in litigation, whether justified or not? Do they seek change orders, whether justified or not? Do they have schedule delays? Are they aggressive? All of these things are important to an owner who has to select a responsible bidder as defined by the statute. Now, when Johnson Roberts is hired, they don't know who's bidding. They're not hunting down BC. And when they begin their process, they speak with multiple references. Phil O'Brien does the Dracut review, and 5 references tell him BC is litigious, aggressive, they delayed projects, presented large change orders, poor work product, and Johnson Roberts provided this information because it was relevant. That's what Mr. O'Brien testified to. I thought this was something my client needed to know. It's important to note that every statement Johnson Roberts made about BC Construction was relevant to BC's status as a responsible bidder and was made to a client in connection with the project. Even that 2016 statement, counsel characterized it as sort of coming out of nowhere, where Mr. O'Brien speaks to the librarian or the library counsel. Mr. O'Brien explained, I viewed that as my client. They provided a grant for that project, and I thought it was important for them to know about the contractor who worked on that project. He said, I've done that before, because he feels it's important for his client to understand how the project went. And this wasn't unsolicited. The library counsel's asking, hey, where's your LEED certificate? Why isn't it done yet? And Mr. O'Brien is explaining, well, there's been delays. There's actually been a lot of delays. This contractor was very difficult to work with. But none of that shows ill will, which is not dislike. It is an intent to harm, an unlawful intent. It came out of the development of case law with malice and ill will and whether malice and ill will were one and the same. So saying, I don't like
Why
somebody.
isn't that a jury question?
What portion of it, Your Honor?
The entirety of it. Why isn't that a jury question? In other words, there seems to be enough meat on the bone with all of the emails, prior history, etc. I shouldn't say there seems to be. There is arguably enough there that one can say, look, maybe their experience with these guys was bad, or maybe JRA has it in for this group. How come the jury doesn't get to make that decision?
Well, Your Honor, because we haven't gotten past the point of personal dislike. Every email and correspondence you see is Johnson Roberts saying, well, our experience with them wasn't good. They weren't a good contractor. The premise of this lawsuit and the allegations made by BC were that Johnson Roberts was sued by the city of Everett and harbored resentment over that lawsuit, and that carried over into this.
And there's no evidence.
That's not true. That didn't happen. So instead, it's, well, you know, we had some normal disagreements that BC says are normal, the architect says are normal.
Why couldn't a juror look at the evidence, though, and say, okay, so they had a bad experience with them, and now they're like Ahab going after the white whale. No matter what, they're not getting the job, and we're making it a point to make sure of that.
Because
Across the board.
that second part of it's not there, Your Honor. There's actually I'd say a more egregious case, Alba versus Sampson, 44 Mass App 311. It was a supervisor and employee where the defendant called the plaintiff, an effing a-hole, and threatened to imprison him over an office prank, made jokes about his clothing, his background, and engaged in uncivil behavior. And the appeals court held that dislike, that animosity, did not support an inference that when the defendant fired plaintiff, he did it without any legitimate reason to do so. And that's really the important part. It is not, you cannot take action that harms someone if you dislike them. Cutting Edge states an improper motive is one that's unrelated to any legitimate business interest. So if, for example, Johnson Roberts got this contract and saw that BC Construction was bidding and called up random municipalities and said, hey, we're not working for you right now, but just so you know, BC Construction, horrific. Worst you've ever seen, do not hire them, they'll sue you. That's a much different situation. This is a case where the town of Drake and down in city of Cambridge are saying to Johnson Roberts, please evaluate this bidder for us and tell us if they are responsible in your opinion. And I would say the characterization put in the two letters actually shows the lawful motive of Johnson Roberts. They did not just use this as an opportunity to attack BC Construction. They included the good references and the bad references. And when Mr. Cresta, BC Construction, was asked, why did Johnson Roberts put in a good review of the St. Paul's residence project, he said, I don't know, but it does make me look like I'm a good contractor.
What's your response to them withholding the Norfolk's good review?
They testified that they spoke with the project architects. Mr. O'Brien testified they spoke with the project architects. Vertex spoke with project managers. So they hadn't spoken with one of the architects from Norfolk, but the people they spoke with, they got feedback from and conveyed that information. The idea that they were going to the Attorney General to circumvent the law, it doesn't make sense. Vertex contacted the Attorney General to say, we, Vertex, and Johnson Roberts have both had bad experiences with this contractor. What's the path here? What's the recourse? And counsel's suggestion that the Attorney General did not advise them in the way that it is recorded in the letter, there's no record of that. That's just an assumption. But going back to what's put in those letters, you have good and bad. You don't have Johnson Roberts saying, well, you know, this other bidder also had some lawsuits, but those lawsuits aren't as bad as BC Construction's lawsuits. You have Johnson Roberts criticizing the second lowest bidder, saying one of the references said they were bad with their paperwork. They're not really focused on public projects. They're giving their client the information they need to make an informed decision about how to proceed. And I think the most significant example of this, if we're talking about withheld information, is the town of Weston reference, who told Mr. O'Brien that BC Construction was entering settlement agreements to avoid getting negative DCAM reviews. And to be clear, I want to be fair, that is not corroborated in the record. We don't know if that happened or not. But if that's true, that could disqualify BC from any public projects. That could have them lose their license. That could be referred to the AG or the DA. So at this point, Johnson Roberts has this golden ticket. They can drop a hammer on BC Construction. It's a level of revenge you see in The Count of Monte Cristo, and they do nothing with it. Phil O'Brien testified, I didn't know if it was trustworthy, I didn't know if it was credible, so I didn't convey it to my client. Why would Johnson Roberts hold back that information if they are trying to hurt BC Construction? It makes no sense to say, well, let's mention the lawsuits BC was involved in, but not the fraud on the government that we believe BC committed.
Let me ask you a different question. You argue that alternatively, summary judgment should have been allowed because there was no expert, because they didn't retain an expert to talk about the standard of care and the norms. Are you making that argument as to the intentional interference claim only, or as to both intentional interference and defamation?
Well, both, because the theory is Johnson Roberts didn't do this review in the way that is customary and consistent with industry standards and the standard of care, that they use this as a pretext to do untoward things against BC.
What case says you need an expert in a defamation case? I mean, assume arguendo that it was an utterly false statement that could damage BC's reputation and caused economic loss. You'd really need an expert for that?
Technically, you don't, but I think in this case it's unique because BC Construction, and most of counsel's argument was, well, we think our JRA should have done this, and we think Johnson Roberts should have done this, and it would have been more reasonable for an architect to talk to this reference or this reference. Well, a lay jury doesn't know how an architect is supposed to conduct a bid review under Chapter 149.
What case suggests that in this context where there is some sort of duty here owed, that you would need an expert in the context of defamation?
It would be Leclerc, or Lafayette, I apologize, because the theory is that Johnson Roberts did not comply with the standard of care here and instead used this as an opportunity to attack one bidder.
Leclerc or LeBlanc?
LeBlanc.
Okay, I think LeBlanc, though, just stands for a general proposition regarding an architect. I don't think it says anything about defamation or anything like that.
It does, Your Honor. You're correct. And I think it's unusual. I think this fact pattern is somewhat unusual. And I do appreciate the distinction here between the level of skill that an architect applies in terms of its services versus a bid review. But the point is that the BC's theory is the bid review was done basically pretextually. And how do we know that unless someone says, well, this is how a bid review should have been done? I do want to touch on the point that BC received jobs after this one from Cambridge and Drake-It, and Mr. Davis, Mr. O'Brien testified they were happy to hear that. Mr. Neophystitis from Drake-It explained that was a much smaller project, and at that time, BC's reviews were better, which is exactly what Johnson Roberts pointed out in its its Cambridge letter. And this is an important point, and again goes through the legitimacy of this review. Johnson Roberts does the Drake-It review in December 2019. They do the Cambridge review in December 2020. The two reports are different because they found different information and reached different conclusions. In the Cambridge report, Johnson Roberts actually characterizes the reviews in a favorable way. They could have just said, well, we spoke to a lot of people, some said bad stuff, some said good stuff. They went out of their way to say the recently completed projects are more favorable. The work product is better. The other issues that existed before are not as apparent. So they're telling their client Cambridge, hey, this is a contractor who had some issues before, still has some issues, but also seems to be trending upwards. And subsequently, Cambridge and Drake-It awarded contracts to BC Construction, which makes complete sense.
I appreciate that. In the last few minutes, one big thing that troubles me is the public interest. This is, again, taxpayer dollars. And as I understand it, the gist of the obligation of JRA here is to give an honest opinion whether this is what's the term of art, qualified contractor. It's not just the lowest bidder, but also the
lowest responsible.
Right.
Yes.
And so if, in this context, there's got to be there's got to be protection for giving an honest opinion, because otherwise you're going to be discouraged. If you can face a lawsuit, you're going to face dangerous pressure to avoid giving the taxpayers an honest opinion. Can you speak to that?
Yes, I think you're right. So there is statutory privilege for the references who give the information. And there's an option for the contractor to legally file a lawsuit against the town, challenging whether the town has complied with the public bidding laws. And reading those together, the statutory mechanism appears to be, well, contractor, if you believe you were treated unfairly or treated wrongly, don't go sue everyone. Don't sue the references or the architect who conducted the review, but you can go to the town and say, town, the architect you hired didn't do a very good job, and you made your selection incorrectly. I was a responsible bidder, and you didn't do a good enough job. BC didn't choose to do that. But that's the protection on what should be on both sides. Contractors not left without recourse. They can go and they can challenge the finding. And the town is responsible for saying, no, we did a good job. And if the town didn't do a good job and didn't have a good reference check, they can blame the architect that they hired. That would be the recourse here, is to say, architect, I hired you to do this reference check, to do these reviews. You did such a horrific job that I was found to have improperly rejected a qualified contractor. Breach of contract claim. It's the same as cutting edge. Those owners could turn around and say to the architect, hey, I just fired my contractor because you told me he was overbilling me by hundreds of thousands of dollars, and it turns out you based that on an assumption. You based it on nothing. And that's really why cutting edge is such an important case here, is the facts are nearly identical, except that architect had no factual basis for what he was telling his client. Here, my client had a strong factual basis and honestly conveyed the information. Whether they did a great job, an average job, not such a great job, it doesn't matter for improper interference, for improper motive and improper means, because there's no evidence of dishonesty.
Can I ask you a question about the defamation claim? Your first argument in your brief is that the statement was an opinion and not a fact. I mean, isn't it true or false whether they required litigation to complete projects? I mean,
well, no, I'd say, Your Honor, it's an opinion because they're saying, well, we've done our reference check. It appears, I don't know the exact language right here, but it appears many of the recently completed projects required alternative dispute resolution to complete the projects. So you're saying we've received some information. Based on that information, our opinion is that it appears many of these projects have required litigation. So
isn't that a question of fact, not a question of opinion, whether they did or didn't require litigation?
No, because you're saying it appears many have required alternative dispute resolution. So if I look at a history of someone's litigation and I say, wow, it seems like they filed a lot of lawsuits or many lawsuits, it's an opinion. Many is not there's not a factual amount for many, and I think the bigger point there is it's correct. The contractor conceded 4 lawsuits in 5 years on public projects. Whether the contractor wants to say that or not is quite a few lawsuits and relevant for the town to consider.
All right, we've gone a little over time, so both sides really well briefed, really well argued, did nice jobs for your clients. Completely different stories, but we'll take the case is submitted. Thank you. Customarily, we take a break after our third case. We're gonna hear one more case and then take a short break. But we're gonna hear the fourth case right now, which is Hennessy versus Cape Cod Hospital, 24P 750. So the Cranberry Commons, we'll get to you. We'll have to take a short break and get back to you after that.
Members of the panel, may it please the court. My name is Kevin Considine. I represent the appellants Francis Hennessy and Marie Hennessy in this case. For almost 40 years, Mr. Hennessy was a police officer in the town of Yarmouth. He had numerous injuries to his right knee. In April of 2017, this resulted in him having a complete right knee replacement surgery at Cape Cod Hospital. The defendant, Dr. Kincaid, performed that surgery. As a result of the surgery, Mr. Hennessy developed permanent nerve damage in his right leg. The nerve damage was diagnosed as peroneal nerve palsy, and it gives him constant debilitating pain going down to his right foot. As a result, he developed what is known as foot drop and has to wear a brace on that right leg. As a consequence of this nerve damage, he was forced to retire as a police officer for the town of Yarmouth. This is a medical malpractice case. It's a little different than the typical one. It is based on lack of informed consent. And typically in...
That's just one... Who are the remaining defendants? Who are the defendants who are relevant here? Is it just Dr. Kincaid, or is it who's Cape Cod didn't file a brief?
The defendants are Dr. Kincaid and Cape Cod Orthopedics and Sports Medicine, PC.
Okay.
Those are the two defendants,
Not the hospital.
not the hospital.
Thank you.
The hospital didn't make it through the tribunal, and they were dismissed from the case.
I'm going to let you get to your argument, and I know where you're going, I think. But, in his deposition, your client repeatedly testified that Dr. Kincaid never disclosed to him that the total right knee arthroplasty surgery posed the risk of permanent nerve damage. Yet you state in the brief that here the materialized risk was disclosed, but whether it was adequately disclosed in a reasonable manner is a determination to be made by a jury. So I guess, is this just, not just, but is this a strategic choice that you're making here?
Well, first of all, if I use the word disclose as opposed to realize, it's a mistake. What we've maintained throughout this is
Here, the materialized risk was disclosed. That's what you say in your brief at pages 13 and 14.
Right. And it was disclosed and it was materialized. He ended up with neurovascular injury.
But your client testified it wasn't disclosed.
That's the whole point here. It was disclosed, but it wasn't disclosed in a meaningful way. When you look at the Harnish case, Harnish versus Children's Medical Center, it's very clear that from that case forward, the court has required that the disclosure be done in a reasonable manner. And in fact,
How can a jury make that determination, whether or not it's reasonable and sufficient?
that's a jury's function, Your Honor. It's up to the jury to decide whether...
Without the aid of expert testimony?
What is the expert testimony going to be? The expert testimony in a situation like this would only apply where there was a failure to disclose a risk that later materialized. So then you need an expert to come in, establish what the appropriate standard of care was, and to opine that the standard was not met because a particular risk...
That seems counterintuitive to me. I mean, let's assume someone was doing a knee replacement and they didn't disclose a risk that, by the way, there's a 70% chance of death if you undergo a knee replacement. Obviously, that's a hypothetical. I don't know if you need an expert for that. Obviously, someone would need to know that before they underwent the surgery. It seems to me the expert comes into play where we're dealing with degree of reasonableness of the disclosure. Do you follow my question?
Yeah, and I just don't think that's what Harnish says. What Harnish says is a physician's failure to divulge in a reasonable manner to a competent adult patient sufficient information to enable the patient to make an informed judgment, to give or withhold consent to a medical procedure constitutes professional misconduct.
Right.
And
I'm focused on sufficient. To build off of Justice Nyman's question, there are degrees of risk. And so if the likelihood of this nerve injury is 0.0001%, that's negligible. If the risk is 10%, 15%, that's different. But you need an expert to tell you the risks. And that in turn seems to be crucial to understanding whether the information for informed consent was adequate. So it seems that you still need an expert, even if you're conceding that there was some disclosure.
I agree with that. I think why this is different is the doctor chose to disclose that risk. It wasn't like he failed to disclose it. He made the decision to disclose the risk.
Well, can we pause there for a second? Because what you're going to say is important too. But this is the problem I think we're all having, which is there's this factual contradiction in your own case. Your client said in his deposition, there was no disclosure. I'm being wheeled into the operating room, and the doctor shoves a paper in my face. I said, I don't have my glasses. I can't read this, and I refuse to read it. So it's not some disclosure. Your client is saying no disclosure, zero disclosure. You're now saying, and it seems sort of at the last second, as the jury was being picked, no, we concede there was disclosure. Well, first of all, what specific disclosure are you conceding? Because I'm confused. And then we can get to what you were going to say.
Okay, so let me back up on the facts, if I may.
Right.
So during discovery, in this case, Dr. Kincaid maintained that in a printed form, it's in the notes, he disclosed along a list of several other potential risks, the risk of neurovascular surgery. What Mr. Hennessy is going to say is nobody ever explained to him what that meant. He's got no medical background. He didn't understand that. We now get to the surgery. There's a lot of question, quite frankly, whether Dr. Kincaid complied with regulatory requirements on informed consent. But putting that to one side, as he's being wheeled into the operating room, Dr. Kincaid comes and hands him, I believe it's on page 170 in the appendix, the consent form and says, here, will you sign that? He says he doesn't have his glasses. What Mr. Hennessy was testifying in his deposition earlier on was that nobody explained to him what that meant, what the neurovascular injury meant.
So if nobody explained to him what that meant, isn't like you're contesting the content of the disclosure, not the time and manner of the disclosure.
It's exactly what I'm contesting. I'm contesting whether the disclosure was reasonable. I'm contesting under Harnish and all those cases that follow Harnish, whether a reasonable adult could make an informed decision to go forward with the surgery based on that disclosure. We don't need an expert to come in to say, yeah, he disclosed what he disclosed. You need an expert only if there's a failure to disclose a risk. And as Your Honor points out, if there's a 1 or 2 or 3% chance there's a remote risk, that doesn't have to be disclosed in accordance with the standard of care. We're not dealing with that case here. This is a case slightly different, I admit, but the doctor elected to disclose a certain risk, and he did not do it consistent with what was required by law as established by Harnish and all those cases that followed. Because a reason, and this is for the jury to decide whether it was disclosed in a reasonable manner so that somebody in Mr. Hennessy's decision
Well, what do you mean in a reasonable manner?
It's a factual determination.
What do you mean a reasonable manner? Like, is he loud enough? Is it in English? Or is it the degree of the percentage risk and what the alternatives are? What do you mean by reasonable?
Whether it was an informed decision, whether it was explained to the patient in a manner that the patient understood what the risk was and was able to make an informed decision going forward. And, the court used the term reasonable manner to a competent adult patient. It's a type of negligence standard that a jury is very well capable of deciding. In fact, if, the lower court judge ruled in allowing summary judgment based on the Zalaskis case. That was a battery case. It's kind of a convoluted fact pattern. But the Zalaskis case specifically said that where the defendant's negligence was not so obvious that the lay person, jury, with their common knowledge could make a finding, you need to bring an expert in. What I'm suggesting is that in a situation where Dr. Kincaid discloses this risk that the patient doesn't understand, you don't need an expert to come in to say he should have disclosed this risk, he should not have disclosed this risk. And what the lower court judge said, and if you give me a second, is the complete opposite. Basically, it's, I believe it's on page 277 of the record appendix, but I could be wrong. But in any event, what Judge Perino said was that you need an expert to come in and tell the jury if the disclosure was reasonable in the manner in which it should have been disclosed. And what I'm suggesting is when you have a disclosure And the question is whether it's reasonable. You don't need an expert to come in. The jury is perfectly capable of making a decision whether something is reasonable. And if you...
I'd like to shift, because we don't have much time, to a slightly different question, the lateness of this disclosure of this new theory. Your opponent makes what I think is an important point. Look, if we had known this was the new theory at the time of the deposition, we would have asked us multiple different lines of questioning in discovery. Most importantly, at least to me, your client knew that nerve damage was a complication of a bad knee, and he was having similar pains, it sounded like, at the time he was undergoing other treatments with Dr. Kincaid. And so one of the questions would have been, because this is relevant to the legal standard, to what extent did you already know that a knee replacement from that other treatment, that a knee replacement would trigger this sort of danger? In other words, had he already told you during, or his staff told you during the treatment, for the other kinds of treatment, that nerve damage was a possibility here? But they didn't ask those questions because they didn't know that that was the theory of your theory of your lawsuit until the last minute. How are they not unfairly treated by this late disclosure?
I don't think that's entirely accurate, Your Honor. Lack of informed consent is part of a negligence claim. The complaint always had a negligence claim. That's what the case is all about. We disclosed we were going forward on the basis of lack of informed consent, I believe, in the pretrial conference report, which I think was filed in August of the year preceding the trial, which was in April of 2024.
So I just want to make sure I've got that right. The pretrial conference report disclosed this defense?
I'm almost certain it did.
Okay. Okay.
I wanted to ask you, you mentioned Record 170. That's a document where it says, number 2 is Dr. Kincaid has explained the risks, benefits, and alternatives. Number 3, and risks and consequences. It's signed by your client on 3/28/17. That's not as he's being wheeled into surgery, right?
That's not what you're
It's
asking?
not as he's being wheeled into surgery.
Surgery is April 6th.
Right. Looking at RA
Yeah,
170.
that's correct. I may have misspoke. That's when Dr. Kincaid signed it.
Well, I mean, I'm seeing it looks to me like F Hennessy 3/28/17.
Correct. That is correct. And I may have misspoke, but that is when Dr. Kincaid signed it, as it was being wheeled in.
Right. Okay. You're saying Dr. And right at the bottom there, Dr. Kincaid signed it, but on 4/6. Right. But your client signed it earlier.
Correct. And what he has consistently testified to, from 2017 until after the surgery, nobody advised him that he ran the risk of permanent nerve damage. Your Honor, if I may real quickly, looks like I'm out of time, quickly raise the issue of Chapter 233, Section 7.
Actually, you are out of time. I think we'll rely, if it's in your brief, we'll rely on your brief for that.
Okay. Thank you.
Good morning. May it please the court. My name is Sandra Wysocki-Kaplis on behalf of the defendants Cape Cod Orthopedics and Dr. Kincaid. As my brother has explained to you, Mr. Hennessy was a police officer with a lengthy history of knee injuries that he incurred during the course of his career as a police officer. He began treating with Dr. Kincaid several years before the surgery, and some of those treatments included prior arthroscopic surgery, during which the risk of nerve injury had been described and explained to Mr. Hennessy. Mr. Hennessy also signed a consent form. The consent was given in the office by a PA of Dr. Kincaid, and then again on the day of surgery, Dr. Kincaid had a discussion with Mr. Hennessy about the
Is
risk.
the signing of the consent form that 328 I was just talking about?
Correct.
Okay.
Correct. So he was clearly given and had actual knowledge of the risk of nerve injury. The record also establishes that Mr. Kincaid suffered from nerve injury prior to the surgery, which was one of the reasons he had the surgery. The only injury that he alleges that he didn't have prior to the surgery was the foot drop, and there is no evidence that the surgery caused the foot drop, that perineal nerve damage caused the foot drop, or that the perineal injury that he had before the surgery as opposed to after the surgery caused the foot drop. And therein is why we need expert testimony in this case, because there is nothing for the jury that is not within the jury's common knowledge to understand how foot drop occurs. And it's fatal to the plaintiff's case in this matter.
Could you address your mootness argument, because I'm not following it?
I'm sorry?
Could you address your mootness argument? I said, because I'm actually not really following it. It's your lead argument. This appeal is moot because Mr. Hennessy could not establish that Dr. Kincaid failed to disclose the risk of nerve injury.
I'm sorry, I'm having difficulty hearing you, but if you just give me 1 second to...
Could you address the mootness argument, which is the first argument in your brief?
Yeah.
Because based on what I've read, I don't follow it.
Sure.
You say whether this appeal, the first issue in your brief is whether this appeal is moot because Hennessy cannot establish that Dr. Kincaid failed to disclose the risk of nerve injury.
Correct.
How does that make it moot?
You know, to be honest, I did not expect this line of questioning.
It's your lead argument in your brief.
I understand. It was a small argument in my brief, and I think the fact that he says in his brief that disclosure was given, that he did receive the warning. So if
But
he
he
received...
says it was unreasonable. It was not done in a reasonable manner, which is a question of fact.
Sure.
That
Well,
needs-
as you had questioned my brother on earlier, this exactly is the content of the disclosure is the key issue here. Canterbury versus Spence discussed the fact that the focus is on the nature and content of the disclosure or on the patient's understanding. And it's been established that the focus is not on the patient's understanding, it's on the reasonableness of the doctor's effort to convey information, not whether the patient in fact grasps it. Now, there may be situations where the doctor's efforts are unreasonable because it's clear that the plaintiff, does not grasp the information, but that's not what we have here. We have a situation here where the plaintiff had prior knowledge that nerve damage is a risk of knee surgery. He had assigned consent. There was deposition testimony from the PA saying that he went over nerve damage. There was deposition testimony by Dr. Kincaid that he went over nerve damage. And even the plaintiff's own testimony, I think, was kind of taken out of context. He says...
Who decides whether or not testimony is taken in or out of context?
Clearly, that's a jury question, but the plaintiff himself contradicts himself, and this goes back to the question that you inquired about. During the deposition, we didn't go down and explore a line of questioning because the informed consent wasn't on our horizon, so we didn't press him. But the question was, is it your testimony that had you known that perineal nerve palsy was a complication or a potential complication prior to the surgery on your right knee, that you wouldn't have chosen to go into that surgery? This deposition testimony was written by or taken by a stenographer who inserts their own punctuation. I propose that the way that this is written is not really how Mr. Hennessy testified. His answer was, I would not, no, period. I had to do something though, period. I couldn't have two legs that didn't work, period. That's why I did the left one, period. But had I known this, I would have toughed it out for a few more years before or gone doctor shopping a little bit better. I think it's clear from Mr. Hennessy's testimony that he did know the risk of nerve damage, and more importantly, he would have had the surgery. He just decided that he wasn't going to go maybe with Dr. Kincaid, because he later had the left knee done after he supposedly incurred these devastating injuries. So I think he did have the disclosure. He did know about the risk of nerve injury. And there's nothing to argue here, because my brother admits that there was a disclosure. So unless there are further questions, I'll rest on my brief.
I've got a sort of a extreme hypothetical for you, but just in terms of what he's arguing in terms of needing an expert. Suppose the patient is deaf, and the doctor orally goes over the risk of the surgery, and then has the patient sign here. Do you need an expert to say that that's not sufficient?
In those circumstances, I would say absolutely not. But that's not what happened here.
So what happened that that you need an expert?
What happened was that's not even really an analogous situation to what I believe is my brother's challenge to this case. It's not that he wasn't given a consent. What my brother seems to be saying is that Mr. Kincaid didn't really appreciate it, or he didn't really understand it, which would be a jury question. But what we're saying is he needed an expert to prove standard of care, and he needed an expert to prove causation. He needed an expert to testify that foot drop was caused by this surgery, that wasn't within the standard of care. And there is no expert testimony. A jury can't make a determination about the foot drop in the absence of expert testimony.
Okay, I think we understand your argument.
Thank you.
Thank you. The case is submitted, and we are going to take a brief break. We'll be back for the last case in no more than 15 minutes. Thank you, everybody. We're back on the record for 24P492, Cranberry Commons Condominium LLC versus Barbagallo and others.
Good morning, Your Honor. Your Honors, I should say. I represent the plaintiff and appellees, Cranberry Commons
Attorney Joyce.
Condominium.
Attorney Joyce, right?
Yes, I'm
Okay.
sorry, Richie Joyce from Newman & Newman. Again, I represent Cranberry Commons Condominium LLC, Road Glider Enterprises, and Frank Champa. This is a very unique situation in that the facts are entirely agreed in this case. There was technically a trial, but in essence, it was a summary judgment motion that was argued in an afternoon before Judge Squires-Lee. So, in essence, you are sitting completely de novo. There are no facts which are undisputed. That are disputed. So we have the entire gambit is on the record. So this is, in essence, from scratch. And we look at this and we look, Mr. Barbagallo signed the operating agreement both as manager and as a corporate member of Cranberry Commons Investors. From there, we look at...
And the operating agreement it starts at RA 184, Limited Liability Company Agreement.
I believe it appears at multiple places throughout the record.
But its title is Limited Liability Company Agreement?
Yes.
And let's cut to the chase. Could you tell us with great particularity what sections of the operating agreement were breached here?
Yes, sections 102, but more importantly...
Which is purposes and powers.
Correct.
Okay. And more importantly, what?
Section 303. So 303 is the manager's obligations. And within that section, it specifically refers back to 102, which is important because that's to further the operation of the LLC.
So let me ask you a preliminary question. A lot of LLCs and corporations have similar provisions in their operating agreements. Are you aware of any case where breach of contract has been found based upon a section that describes the purposes and powers of an organization? Any case in Massachusetts where sort of an organizational structure has been the basis for a breach of contract claim, a successful one?
The answer is no but. And the but is when you look at 303, that's specifically manager's duties. And it says, look at this section. So it's not just a purpose and powers question as you ask. It's 303, and 303 says, oh, you got to look here for this definition as well.
So you're getting to my next question, which is, are you aware of any case in Massachusetts where a successful breach of contract claim was predicated on a similar powers and duties section of a contract, an organizational contract, I'll call it?
I think it's similar to the Chokel and the Allison case. Both of those are predicated upon an operating agreement or bylaws, whether it be freeze out or the like. If it says, the language says, your duty is to hire employees, subcontractors. Your duty is to pay them. If you hire a subcontractor, they do the work, and you take their check and put it in your own pocket, that is breaching the obligations specifically specified in the operating agreement. This isn't just some general, oh, you have to be a good guy in dealing with business. But even so, we could succeed on that general theory, but this is very specific. It says you must manage the real estate and you must manage the personal property. Well, I don't think anybody disputes in this case, and I haven't heard a dispute, that a bank account of the LLC is personal property. And clearly, taking money that was meant for an other individual or entity and putting it in your own pocket is not managing and maintaining the personal property of the LLC. And here, there is no dispute. That money was taken. 100%, everybody with the facts are agreed. That money was taken from the company and put in his personal pocket for his benefit and for his family's benefit. And that's agreed in the record.
Can I ask a really basic question, and I apologize, but your opponent says in their brief at 6, Barbagallo was not individually a party to the joint venture agreement. I understand that he was the sole member of an LLC. But there are two agreements. There's the joint venture agreement, then there's the operating agreement, and he's serving as the manager in the operating agreement, right? And I get it that he signs the operating agreement as Peter Barbagallo. But so he couldn't be individually liable under the joint venture agreement because it was under the shell of his LLC, but he can be individually liable on the operating agreement suddenly?
I think arguably under the joint venture agreement, he may not be liable under the joint venture agreement, but I think the operating agreement refers back to the joint venture agreement, so he then signs as the manager. Now, as your honors know, in this Commonwealth, you are allowed to set up a LLC or a corporation with the corporate authority and then have a manager in an LLC purpose be another corporate entity. You could have manager of X corporation LLC as a manager.
Okay.
Here, Mr. Barbagallo chose to be individually a manager. So there is no...
That's undisputed in the record?
Yeah, it's undisputed that he signed individually as manager. Okay. Now, my brother argues that...
He shed the corporate veil, which he used in the joint venture, to sign the operating agreement as manager. Seems like a weird thing to do.
Well, he's not, there's no piercing the corporate veil. He signed individually as manager.
Okay.
His obligation as manager is to follow very specifically the duties.
Yeah.
2 duties that he violated: maintaining personal property and paying contractors. Okay. These are express provisions. These are not even the implied provisions, which obviously we made claims for breach of the implied duty, a covenant of good faith.
How is your claim any different from a claim of breach of fiduciary duty?
The specific language in the operating agreement is a breach of contract. If you have language that says, you must do X, you are obligated, you signed, you got the benefit of the bargain, and it says you must do this, that isn't a general, you must be good and have this fiduciary duty to one another. This is an obligation of contract. You're talking about a duty to one another. That's not the case here.
So I had trouble following before, so I'm going to ask, and I didn't ask before, I'm going to ask you now. Exactly what in 303, A, B, C, D, is there manage real estate, manage property? Exactly what words are you looking at there?
Your Honor, if I may just flip to that section.
RA 89.
Yeah, we got it at page 89 of the record appendix, if that helps. Page 22 of the operating agreement.
I would specifically refer to Section A, to manage the business and affairs of the LLC and for the purpose to employ, retain, or appoint any officers, employees, consultants, agents, brokers, professionals, or other persons in any such capacity for such compensation and on such terms as the manager deems necessary or desirable.
I mean, didn't he do that?
No, he did not.
I mean,
because he didn't pay the compensation. It specifically says it has to pay the compensation that he deems desirable. The desirable amount is the amount that he contracts for the sub to do basement work, let's say. That's what he deems desirable. That's the best contract, as the DCAM cases, the lowest possible bidder, responsible bidder, he picks them. Now his duty is to supervise that work, and once that work is done, then he has the obligation to pay them. There's no discretion in here. It's to compensate them. This isn't a duty, and then obviously every contract has a covenant of good faith and fair dealing.
Right. That second one seems much easier for me to follow. I mean, focusing on that, it seems clear that whatever the implied covenant of good faith means, it means don't steal from the venture. So, right. So if he's individually responsible, that seems to me like a simple contract theory.
Exactly, Your Honor. And again, I think it's expressed because it says maintain the personal property. If you're stealing from the company, you're not maintaining its personal property. And again, it's undisputed that he was solely responsible for the operation. So it wasn't like other people. It was him. He admits that he took the money. None of that is in dispute here.
So, I mean, it's arguably both. You make an argument that it's a breach of contract. It's clearly a breach of fiduciary duty. So, doesn't the case law ask us to look for the gist, whatever that means?
It does. And so let's look at the two most recent SJC decisions that I cite to. Allison and Chokel, they both involve operating agreements. The SJC has said it is a breach of contract when you don't follow and you don't have the good faith that a reasonable person would have relied upon for the obligations of the other individual. And, I mean, you look at the Barber case, which is a little bit older, but that even says that a fiduciary duty, the statute of limitations would be 6 years in that case. Because this is a contract-based claim. This is not a tort. This is not a standard automobile accident, which you heard, I think, 2 or 3 cases ago. This is very different.
But if we disagree with you, I mean, you said this is not but the point to me is it could be both. This could be both breach of fiduciary duty tort, and it could be, depending on the party's contract, which you're pointing to, a breach of contract.
Well, it could be, and the case law, in fact, says that you can bring both under the 6-year statute of limitations. Look at the Barber case. That specifically says that even though the fiduciary duty claims would be normally 3 years, because it's based upon a contract, the sister had the right to bring that for the land on Hodge Hill or Hog Hill or something like that was in that case. That specifically says you look to the action, and the fiduciary duty on that claim piggybacks. Now, we dismissed, and it's not disputed, we dismissed the fiduciary duty claims. I say in my brief that we could have proceeded because if you look at the Barber case, but that's not before you. What's before you is this a contract action or is it not? And again, we look at the most recent case that I asked you to look at, the Anderson case. And even though that's a snow and ice case, I think there's important language from Prosser, specifically imposed apart from the independent of promises made and therefore apart from any manifested intention of the parties to a contract or other bargaining. Therefore, if the alleged obligation to do or not to do something that was breached could not have existed but for the manifested intent, then contract law should be the only theory upon which liability would be imposed. Well, he didn't have a duty other than he was the manager and he had an obligation under that written document. With respect to the last issue in my brief.
Actually, before you get, I have 2 quick questions. Well, one's quick. Do you agree that if you prevail on the breach of contract claim, then you prevail on the breach of the covenant of good faith and fair dealing, but if you don't prevail on breach of contract, you don't prevail on good faith and fair dealing.
No, I don't, Your Honor.
Okay.
I believe that there are two separate and independent clauses. If the express language, if the reading of Your Honors is that the language in the express provision is not sufficient for a breach, which I argue it's very clear, the good faith and fair dealing is still a separate claim.
Fair enough.
With respect to my last issue, there was a default.
Actually, I have one more question for you. If our panel chief will give you more time perhaps, but we'll see.
For you, yes.
But thank you. Here's a hypothetical. I hire you to be a caretaker at my home, and your duties include cleaning the property and watching over the property. You go into a desk drawer and you steal cash and spend it on whatever it is you want to spend it on. Clearly, there's an action for conversion I would have against you. Are you claiming I would also have a breach of contract, and assume there's no statute of frauds issue for purposes of the hypothetical?
Well, I would specifically ask you, I just hired to be a cleaner?
I hired you to be a caretaker over my property.
You mean real estate
and to clean
property
it.
in general?
My home. And you take money and you abscond with it. Is there a breach of contract action there in that hypothetical?
I would say that in that hypothetical, there would be a breach of the implied covenant of good faith. There may not be an express provision where it's different here. In that hypothetical, there may, as you say, there may be both. There may be the breach of implied covenant of good faith as well as a conversion claim.
And again, you'd be relying on Chokel and Allison as your best
Yes.
authority?
Chokel, Allison, and I believe it's Harrison.
If it's in your brief, I have it, so don't worry about it.
It is.
Very good.
Your Honor. May I have just one moment relative to my last issue?
I want to give him 30 seconds.
Yeah, take 30 seconds.
Sure. There was a default entered. The default can't be waived. It takes good cause to set it aside, and that can be done up to time of judgment. It was never set aside. Therefore, Mr. Barbagallo is in fact defaulted, remains defaulted, and because because of damages were stipulated to, judgment must enter for the $1 million.
Okay. Thank you. We'll hear from...
And I'm happy to give that case site either.
If it's in your brief, we have it.
It is. Thank you, Your Honor. Thank you, Your Honor.
Members of the panel, may it please the court, Mark Kornitsky for the defendant appellees Peter Barbagallo and Cranberry Commons Investors, LLC. The trial court correctly awarded judgment to the defendants based upon the 3-year statute of limitations. The claims concern the defendant's embezzlement, which clearly was tortious conduct. Judge Squires-Lee correctly ruled that the gist of the action reveals that the plaintiff's breach of contract and breach of implied covenant of good faith, and fair dealing claims are based on defendant's tortious conduct after entering the agreements, not on any alleged breach of defendant's specific contractual obligations thereunder. The case that really is on point is the Woodcock v. American Investment Company case. At 376 Mass 169, it's in the brief, 1978 case. That was a shareholder derivative claim in which bribes were paid using corporate funds, and the court held, quote, "The allegations of the complaint rest on a claim of conversion of funds, plainly a tort claim." I have cited in my brief cases where contracts and torts can be pursued. There's the Anthony Spear 4 v. Crandall dry dock case. And in that case, the SJC permitted the contract claim because there was a separate agreement. And the court stated that the promise, if given, imposed a higher duty on the defendants than the implied promise that in designing the mooring system that would exercise the standard of reasonable care required of members of their profession. In that case, Anthony Spear 4 Restaurant engaged an engineering firm to design a cradle system to moor a cocktail lounge. And in the contract, they provided, it's alleged that they provided that it would withstand gale force winds, 100 miles an hour, I believe, and tidal force. And it did not, it sunk. In that case, there was a higher level of performance guarantee. That's not what we have here in the operating agreement.
Right, so can you just address your opponent's specific claim 3.03A in the operating agreement, why that wouldn't, I mean, there's two claims, that's one of them, the contract claim, or the explicit language in the contract to manage the business affairs of the LLC, which it seems to me include not stealing from the LLC.
I would agree that there's a breach of fiduciary duty claim that is violated by that term.
Why does it not breach that contract claim?
The gist of the action is a tort claim. It's the same operative
Right, but sorry,
facts.
you're just repeating what the judge below said. But why? Why is it the gist tort? Why? And again, stepping back, do you disagree with the premise that the gist of something could be both tort and contract? And if you agree with that, I think you have to explain why this is not a breach of the contract, and the best one I can see is 303A.
Well, I think first there's a distinction that should be analyzed first between the individual claims and the claims against Cranberry Commons investor.
Right.
Because for the operating agreement, Peter Barbagallo enters that individually as a manager. And although my brother stated that the agreed fact put Barbagallo in as individually, at the record appendix, page 73, number 2, also on March 11, 2011, Ciampa as manager of RGE and Barbagallo as manager of CCI enter the Cranberry Commons Condominium LLC operating agreement. So I'd suggest it was entered as manager. And with respect to your question, the counterparty to the operating agreement is the other member. It's Cranberry Commons investor. Barbagallo enters solely as manager. He's only signing up for what he agrees to do as manager. 3.03, powers and duties, it expressly says what the powers and duties that Barbagallo has. And I would suggest it outlines the things that he agrees that he would do. And he did do them. Did he steal? Yes. And that's why it's a tort case. That's why it's conversion. He stole. That's what this, there's no question that the same operative facts, be it for the contract claim or the tort claim, are the same. It's all about his conversion.
Okay, so moving on to the other theory, the implied covenant of good faith and fair dealing. If good faith means anything, how can it not mean stealing from the person you're contracted with?
Right, and so the analysis that the courts have taken has been that the covenant of good faith and fair dealing can't supply terms that aren't there in the contract. The parties were free to contract and define this operating agreement as they chose. Well, they didn't have anything further than those, this real stretch to try and reach the purpose clause and the property clause.
So do you have to put in the contract, and party X will not steal from the company?
You don't have to put that in there. And when the party steals, it's a tort. That's the remedy.
But in
Unless you have
But in
something
order
further.
for there to be an action under the contract.
So I would suggest that the powers and duties, we have to look at the contract. And when it says at 3.03, and these other provisions in the operating agreement, that all of those items have been fulfilled. So if I could just go through those briefly.
You don't have to read from it. I have 303
Well,
in front of me.
Can I ask it a different way? Attorney Joyce argues that if you're right, you can never sue under an operating agreement.
For a breach of contract, if it's a higher level, if it's crystal clear what it is, for instance, the court did a nice job of explaining the issue in the Mass Housing Opportunity Corporation, the Whitman and Bingham Associates PC case. That was another one where there was a statute of limitations issue, and the question whether the contract claim would survive, and the statute of limitations. In the court, it was the engineering firm, similar to the Crandall case, the engineering firm had provided that they designed a septic system, and they gave an estimate that the cost was going to be $200,000, and it escalated to $700,000 for a full wastewater treatment plant that was necessary. And the court held that, in this case, despite MHOC's casting of Whitman's alleged promise in terms of an express warranty, the contract action relies on the same factual allegations set forth in the tort claims, principally that Whitman negligently failed to identify the proper system required for the development and thereafter concealed the true cost of the system. The gist of the action, accordingly, is one of tort, not contract. So if you found that, yes, those are violations of contract terms in the operating agreement, it doesn't change the analysis that the court needs to perform as to when the statute of limitation runs. It's a tort statute of limitations because it's the same operative fact. You don't get an extra 3 years to bring these claims, these disguised tort claims.
I think what you just said is that, yes, a breach of contract, we can agree that it's a breach of contract, but if it is a tort, the gist of the wrong is a tort, it doesn't matter that it's a breach of contract, and you're restricted to the 3-year statute of limitations. Is that what you just said?
Saying that in a mixed case where it's out of the same operative facts, where you're relying for the contract or the tort, it's the tort statute of limitations.
Okay, so it can't be both and. Effectively,
It can't be both.
it has to be either tort or contract.
If it's the same operative fact. So that's the distinction with that PR4 case, is that the operative facts for the negligence was that they improperly designed the system. The contract cases, we gave a higher standard. We said it's going to withstand the wind. And
Sorry. So in other words, on these facts, if bizarrely the contract actually said, I, the manager, promise not to steal from the company, under your theory of the law, that wouldn't allow him, the plaintiff, to have the benefit of the 6-year statute of limitations, because it's also a tort.
I would agree with that with you, that it would present, it would present that higher standard.
Okay, but
It was
I
an
understand.
express representation.
If they had been smart enough to put that in the contract, he gets six years. But the implied covenant of good faith and fair dealing, it's the words implied and covenant. Don't you disagree that those can't extend beyond the explicit promises in the agreement to any duties?
Well, first, I don't want to blend it with there's a distinction between Barbagallo individually and CCI, and CCI is a member, okay? Barbagallo is charged as the manager with the 303 duties and powers. And with CCI, the claims against CCI, they're not part, the 303 powers are for the manager, not for the member. So I'd suggest there's a distinction. I don't want to lose that distinction. And The claims against the individual manager that are presented by the appellants are limited to what's in the contract. And what the covenant of good faith and fair dealing does, it can't expand the contract. It says that no one's going to do anything to get in the way of the performance of what the contractual terms are. So it's my position that you first have to look at it separately, the individual manager, the member, and analyze first the contract and what the contract terms say, because the covenant of good faith and fair dealing can't expand upon what the written agreement is.
Right. What's your best case for that fundamental principle, that the implied covenant of good faith cannot expand on the actual articulated contract? Because it seems like that renders the implied covenant
Yes, so
meaningless.
I would say a case that does an excellent job of defining it is Uno Restaurant v. Boston Kenmore Realty. In that case, there was a right of first refusal for a tenant in a commercial space, Uno Restaurant, in the Fenway area, and the owner of that unit, which owned many other units in the same building, received an offer and gave that same offer under the right of first refusal to the tenant and said, okay, you have your opportunity to match it. The tenant said, well, it's 40% of the building or whatever percentage it was, we'll pay 40%. And they said, no, you didn't match it. And they sued saying you violated the covenant of good faith and fair dealing. And the court said you can't add terms to the contract. The contract provided, if you get an offer, you got to give us our right of first refusal, which they did. They complied with it. So they didn't do anything to interfere. They didn't go out and solicit that the buyer
What's the
offer for that.
I didn't see that in your brief, the citation for that?
Sure.
If it is in your brief and I missed it, I apologize.
441 Mass 376.
Thank you, Your Honor.
Thank you. But, well, I'll check, I'll look at that case, yep. Thank you.
And further, the Weiler v. Portfolio Scope case at 469 Mass 75, 2014 SJC case, that case does an excellent job of saying when the implied covenant does apply for a contract and, you know, to try and define what the standards are. So you have a case that shows where there was compliance and then showing where there was a violation. And I would also just briefly like to point out that in the operating agreement at 308, the manager, there's a provision in there disclaiming liability except for, it would be one of these things. It would be for theft. So I've also pointed out that the contractual obligation that really is in the operating agreement is Barbagallo's as manager to look for indemnification, which he never sought. He never sought any indemnification. He committed a tort and did not look for any indemnification. Thank you.
Interesting case.
Yes, thank you. Thank you both. The case is submitted. I want to thank lawyers, thank the court officers and clerks, and thanks again to the faculty and students from the Massachusetts School of Law. Do you want to say something about meeting them later?
Nope, they know where to go.
They know where to go. Okay, so we'll be adjourned.